Hello, everybody. I'm just waiting for people to come in from the lobby. Just letting everybody in now. Welcome. I'll just wait another 30 seconds or so, see if anybody else is going to join us from the beginning. Thank you for joining us today. Okay, I'm going to get started. Welcome to this webinar aimed at micro, small and medium-sized employers in the social sector, i.e. those organisations working not for profit or not for personal profit. I'm Jan Golding, an associate consultant at Roots HR, and some of you may know me as its founder and former chief executive. This webinar is free for social sector organisations and it's funded by profits generated from our fee-earning consultancy work. This webinar is being recorded so it can be accessed from our website in future by people who are unable to attend today. By attending this webinar, you consent to the content being recorded. Your video and audio functionality is automatically turned off by the webinar technology. I'm going to talk for about 30 minutes or so. Please feel free to put your questions in the chat function as we go through, and I'll answer questions at the end. Please be aware that when you enter something into the chat function, it can be seen by everyone on the webinar. If you want to ask a question, but you're concerned about confidentiality, please contact us separately for a free 1 hour of consultancy advice. And if this webinar gives rise to questions for you that are not answered today, then I'll explain at the end how you can access further free or paid for services or support from us. So at Roots HR, we refer to individual employee matters as cases or casework. And on the next slide, we'll talk about when that becomes contentious casework. In this webinar, we're going to be talking about the types of cases that Roots HR are currently seeing in particular, the key weaknesses in employer organisations which exacerbate these and which can escalate them, how your organisation can avoid them, strategies to help you address swiftly and minimise situations when they occur, and guiding principles for our clients in managing situations. So hopefully to, again, help you minimise, and also how to get free support from us as well. So we're going to be talking about individual employee situations that become difficult in some ways. I'm sure we all like to think of our workplaces as harmonious places where everyone cooperates and works as a team, and for most of the time that will be the case. However, we have to accept that the relationship between an employee and their employer is based on the contract of employment, and that any contract creates two parties. And those two parties will, in some situations, have separate interests. So whilst for most of the time, hopefully, relationships at work will run very smoothly, from time to time, an employee may become unhappy about a matter at work and they may raise it with the employer, either formally or informally. And we know this as a grievance. And you'll know that phrase, I'm sure, that word. And from time to time, an employer may be unhappy in some way with the behaviour or conduct of the employee, or with their attendance levels, or with the performance at work. In these circumstances, an officer of the organisation, it might be the line manager, it might be another manager, it might be the chief exec in a senior case, or a trustee or a director, that person will deal with it formally or informally with the employee. And that might take the form of a simple discussion of the problem with the employee in a one-to-one or supervision meeting. But if the problem is more serious, or if it isn't resolved through initial conversations, there may need to be a disciplinary or a capability process. Situations like that are fairly uncommon, but when they arise, they should be viewed as part of everyday working life. Your organisation may well have policies that set out how managers should react and handle these sorts of things. The aim is that the matter is dealt with in strictest confidence to the employee's employment, so only those that need to know about it are informed and involved. The processes and the scenarios on this slide are not in themselves necessarily contentious. Some of them, bullying and harassment might be, of course, but not all of them are. And employers are expected in law to address them fairly as necessary and when they arise. The aim is that the two parties, the employer and the organisation, act respectfully towards one another in naming and resolving the difficulties, and often, in most cases, this is the outcome. These cases don't always become contentious. However, sometimes the issues raised between one party and the other are more complex from the outset, or they become heated, or they become aggravated by one or both parties. Sometimes the employee's grievance may allege they are the recipient of behaviour which amounts to bullying or harassment or to discrimination. Sometimes the employee may claim that in the course of their line manager managing them, they have been harassed or discriminated against. These cases can be particularly difficult and unpleasant to resolve. It can be even more distressing for all parties if the employee is sick or disabled or vulnerable in some way. Sometimes the employee will refuse to respond to employer communications or put other barriers in the way of processes taking place. So these are the sorts of cases that we start to refer to as contentious. Harassment and discrimination are unlawful and can be very damaging for an organisation's reputation. So employers, particularly those in the social sector, will want to take all steps to ensure allegations like these are properly addressed. Managers and indeed members of your governing body, for example, your board of trustees, should be trained to recognise situations as they arise and to raise them within the organisation appropriately so that the right action can be taken. In the more serious cases where differences are not resolved, sometimes the employee will resign or the employer will dismiss the individual. Lawfully, we hope. In some cases, there can be a mutually agreed termination of the employment with some settlement terms and a payment set out in a legal settlement agreement. And in some cases where that doesn't happen, the employee may seek redress through the ACAS early conciliation process and the employment tribunal system if that's unsuccessful. So the stakes can become pretty high, can't they, for both parties? The sort of issues I've been referring to here can't always be avoided. For example, if an employee is underperforming or two employees have badly fallen out or an employee submits a grievance, those things have to be addressed. And it makes sense to do all you can, though, to deal with those issues quickly, to nip things in the bud if they look like they may be going to escalate, and to prevent escalation wherever possible. And as we all know, the risks that come from employment cases that don't resolve to the satisfaction of both parties, from simply distraction from the organisational purpose through to large legal costs or compensation in the employment tribunal and reputational damage. None of those things are desirable, of course, and they all need to be minimised as much as possible. But we have seen an upward trend in the number of employment cases coming into our office and an escalation in terms of the difficulties this leads to in the employment relationship. And we see that starting earlier in the process, and I'll explain in a bit more detail now. So here are the current trends and recurring themes that we're seeing predominantly. These are by no means the only things we're seeing, but these are the most common ones. So in many cases, in many ways, the nation's workforce is still quite unsettled and potentially even volatile after 2 years of lockdowns and disruptions due to the pandemic. There really is a whole new normal emerging, but no two organisations are the same as to what it might be. In most organisations, it seems to us that boards and managers are saying, let's get back to it. And there's a drive and an ambition in the sector for growth, expansion, development, innovation, that sort of thing. But it can lead to what I referred to as catalytic events for employers, catalytic events rather for employers. So by that I mean things like work processes and practices are changing. For example, many organisations are trialling hybrid working. And in organisations, work standards are changing. For example, funders are expecting more outputs for less money. And we know that's not new, that's not a product of the pandemic, but it's part of the current landscape. It puts pressure on contracts and it puts pressure on teams to deliver more for less, and that's hard. And team dynamics are changing generally because managers and their team members are in different locations, perhaps working different hours now, working in a matrix structure. And there's loads more. You could tell me more, I'm sure. Sometimes these things in themselves lead directly to problems with employees who can't, for whatever reason, or don't want to adopt what's required of them in new ways of working. In other cases, managers are doing their best to respond to an organisation's changing expectations, perhaps by managing an employee who's not on board or whose performance needs to improve because of these things. And in some cases, the response managers receive is not always one of cooperation, but it might be one of resistance or even counteraction, such as the individual going sick or putting in a grievance or accusing the manager of discrimination or something like that. So these on the slide here, things like employee grievances in themselves and or connected to disability discrimination, race discrimination and harassment, they are the most common recurring themes we've been seeing in cases for the last 2 to 3 years. And they're arising possibly because managers are managing and employees are resisting in some ways. Not always, of course, not always, but sometimes. And they're arising just simply through grievances of their own volition. And I note that there's been significant events like the George Floyd murder in the US in May 2020, which have led to things like an even higher level of racial sensitivity in society than we previously knew. There are, understandably, some of that comes over into the workplace. There are expectations of inclusivity and kindness, and these expectations extend into the workplace and can give rise to problems when they're not met, when they don't meet an employee's expectations. For example, and the bar has become, for example, where the employee interprets themselves as being upset or offended by something that another employee or a manager has said to them, the bar has become lower in our observation in terms of employee sensitivity and expectations generally. So where we're seeing employee grievances, they're not just because an employee is upset about some events that have taken place themselves. They often claim that the events that led to the complaint constitute disability discrimination or racial discrimination or harassment. And where employers are attempting to manage employees, where there is resistance to this, the employee in some way interprets the attempt as a disability discrimination matter for them, or a racial discrimination matter for them, or harassment. Sometimes other forms of discrimination are involved, or sometimes victimisation is included, but the most common recurring themes are the ones that are on this slide. Now, I'm not saying that every attempt to manage an employee goes this way. And I would stress again, this should not stop you from having normal management conversations or following your processes, policies, procedures with employees, or from managing employee sickness or performance or conduct fairly. Please don't infer from this webinar that we think that employees are oversensitive or that their claims are conjecture, nor that we think the employer is always culpable, because we don't. What we're simply saying is that the number and frequency of these cases seems to be getting higher. And the stakes are higher with these types of cases because reputationally, an organisation and the people within it don't want to be accused of harassment or discrimination in any way. So inevitably, people involved adopt protective positions quite quickly. That's understandable, perhaps. And sometimes if the board are required to be involved because the matters are quite senior ones, trustees will even resign and leave, citing protecting their reputation as the reason. And settling cases of this type, those that involve discrimination, either in or out of the employment tribunal, will typically be more expensive than a straightforward unfair dismissal case, because it is a separate individual claim. So there's some other information that is well worth sharing with you. There's some other new features that we're seeing becoming the norm in employment cases. You might say these are not new. We've had them before in our organisation, and maybe you have, and certainly we've been seeing them for a number of years. But we're seeing them more frequently now. They are becoming much more the norm. So it's increasingly common for an employee to instruct a legal advisor, not a trade union rep, but actually a solicitor or a legal advisor, early on in the process, even when the employer is still going through their internal processes. That can mean that you as the employer receive a letter from a solicitor on their behalf, setting out accusations and adopting an adversarial position. Sometimes there will be embellishment of events. You don't agree with them. Usually you might recognise them, but they're exaggerated beyond what you recognise, that have led to the employee becoming unhappy. And there are often legal claims that we see that are included that the employer says, that we would say are spurious based on the facts given to us by the employer. And we know those wouldn't stand up if tested in court. The employee may state that their protected category, for example, their race or their disability, is the assumed reason for the treatment they allege that they're experiencing in the absence of any other reason. So, for example, an individual might claim a medical condition they have is a disability under the Equality Act when it's by no means apparent or accepted by all parties, or it's come out of the blue. And similarly, they may state they are the only person in the organisation in their racial group, and therefore the employer must be discriminating against their category because there's no one else employed in the same category. This is the sort of thing that we're seeing. Typically, these letters will object to the process the employer is following, and in some cases to the managers or the people that are involved, the officers that are involved in delivering it. And in some cases, the employee refuses to cooperate with the process unless, and that might be unless a different manager is put on the case or unless an investigation is carried out by an external party. In some cases, the employer's HR officer or their HR representative is accused of being conflicted, and in some cases, even an outsourced consultant might be accused of bias. It's critical that if you receive a communication like that, whether it's sent by an employee themselves or whether it's sent on their behalf from a legal advisor, that you as the employer carefully consider the comments and the requests within it. In some cases, the conflict stated might be real or based on reality, but in some cases, what's requested in the letter can be delaying or avoidance tactics and not reasonable for the employer to follow. And it's important, I think, that you hear that from us, because often employers think, well, this is what the employee's requested, I automatically should do it. It's by no means always reasonable, and it's certainly by no means always helpful to the case. And it's not a good idea, generally speaking, as a principle, to delay processes that need to be followed. We'll come on to talk more about that in a minute. What it is a good idea to do, it's a good idea to keep an audit trail of any decisions that you make as a result of getting such a communication from an employee or their representative, such as who was involved in the decision that you decided to take, what was considered, and what the ensuing decisions were. So, for example, if they ask for a manager to be taken off the case and you decide that you will do that and put a different manager in, it's a good reason, a good thing to do, to have an audit trail of why you've done that, who was involved, and so on. And it's important that you do respond in writing to the employee's communication or to this communication if you don't accept the employee's position on everything, which often the employer doesn't, because otherwise, by default, what the employee has written or their representative has written is kind of deemed to be accepted. So you don't have to respond on every point. It's sufficient to go back and say, we've got your letter of this date and we don't accept every point within it. And we're dealing with that through a grievance procedure or whatever you might be doing. But it's important that you respond to that letter. What we would say is that you don't necessarily have to, and shouldn't actually, respond to the legal advisor. It's not a good idea, generally speaking, to get involved, particularly in the early stages of your processes. It's not a good idea to start dealing with the employee's legal advisor, because it's not a legal matter. It's an internal process that you're dealing with the employee, and they're part of the contract, not the solicitor. The employee is the one in the contract of employment with you, so they are the one that you need to respond to. So typically in those situations, if the letter comes from the solicitor, we'll write back and say, thank you, we're going to reply to the employee, and then the employee gets a letter back saying what the employer is going to do as a result of the letter. What else do I need to tell you on this front? What I will say is that we see employers who feel powerless when they get such objections, particularly presented by solicitors. It can feel really intimidating for an employer who needs to protect its reputation, but particularly for charity sector employers with unpaid trustees as directors and the charities commission to answer to, and the general public as a major stakeholder. Having to respond to situations like this can be really stressful. Not all organisations in our sector will have people on their boards or at the top of the organisation who are sufficiently knowledgeable or experienced or resilient to deal with it. And so therefore many organisations will simply not themselves be sufficiently resourced to respond. It might be instinct to refer to an employment law solicitor at these times, and that would be understandable. We partner with a solicitor in Cheltenham called BPE, who we've been with forever, many, many years, and they're excellent. We can introduce you to their employment law team if that's what would be helpful. But if you're still following internal processes, it's quite reasonable that you simply use HR advice in the circumstances. So if you're going through a performance management process and the employee is objecting, or resisting, it's just an internal process. Keep going. We'd usually recommend you continue with your internal process, albeit with regard to whatever concerns or objections they've raised. Rarely would we recommend you cease it, but we might in some cases guide you to pause it for a period of time. There are ways of engaging the employee or showing them that you have made all reasonable endeavours to engage them, demonstrating that point, and to concluding processes fairly, even when the employee is resisting. But you may need some external HR support in those circumstances to make sure that what you're doing would be deemed reasonable if it was scrutinised, perhaps in the employment tribunal down the line. It would be unreasonable in some cases to expect your in-house HR capacity that deals with your everyday recruitment and so on to be able to deal with a conflictual situation like this well. They might not have the experience to do that. I'm going to talk about some strategic considerations in view of what you've just heard around this topic. So some organisations you have to bear in mind that if a dispute or a conflict like this arises in some way, shape or form, it might end in the employment tribunal. I do get people saying to me sometimes, why are we talking about legal consequences here? Well, because that's where it might go if we're unable to satisfy an employee in terms of what they think is a reasonable outcome to the situation. So it might end in the employment tribunal. You've got to keep that in mind. And some organisations will have insurance to cover the legal costs of and any compensation associated with that. The trigger point, this is important, the trigger point for notifying your insurer of a claim varies massively from policy to policy, but it may in some cases be really early in the process, for example, when a grievance is received. It's really important to be aware of triggers like that and to make sure that you comply with them so that you don't lose the opportunity for insurance cover. And if you haven't got insurance for employment disputes, it's not necessarily always expensive, especially if you're starting from scratch. It is well worth considering. Excuse me. Mediation. This is probably the most often missed opportunity, I think, for employers. Spotting problems early and having a really solid opportunity for mediation, which is really supportive for both parties, offering that early in a dispute or in a conflict situation can be incredibly impactful for an organisation. It won't work in all the situations that we're broadly covering here today, but where there are two individuals involved in an organisation or two groups of individuals involved, mediation can be incredibly impactful in resolving the thing. It needs to be well set up and it needs to be impartial so that the parties feel totally safe and can have confidence in the process. But build mediation into your policies as an option. It can only ever be voluntary at the earliest stages. We've got some great mediators in Roots HR, so talk to us early if a conflict arises. We've got a good track record of success in mediation. Frustration of contract is worth bearing in mind, as if a dispute starts to harden as well. Some employment disputes become so entrenched that there are legal grounds to end the employment relationship, but the bar is fairly high for that. We can help you achieve a lawful dismissal in circumstances like that. So this is where the contract can't continue because the employee has become so entrenched in their unreasonableness that they could never recover and come back to work. That in some circumstances, again, can be a bit of a missed opportunity for employers, and it's worth considering, but remember the bar is quite high. Settlement, where there's fault on both sides or where there's benefit for both parties in what's called a no-fault settlement, this can often be the best and even the cheapest way forward. We've got huge expertise in negotiating settlement agreements in a wide range of disputes, and we can administer the agreement on behalf of the employer. It's often good to get advice at the start of that process if you're planning to go that route, just in terms of how you position it and introduce it with the employee, particularly if they appear not to be looking to exit the organisation. And finally, learning, another important factor here. I can probably count on one hand the number of times I've been asked to take part in a learning review when there's been contentious casework going on in an organisation over the years. If you have a contentious case in your organisation, please do have a review with the relevant parties and take the learning from the situation and act on it. That might be things like making sure there's consistent supervisions taking place across the organisation, rewriting policies, training managers, those sorts of things. But have that learning review and be honest with yourselves about it. Often I hear of where the blame is put entirely on the employee because the employee's adopted a particular position. Well, actually, let's have a real think. Let's be honest and have a real think about why the employee decided to adopt that position. What went wrong in the psychological contract or the actual contract with the employer that led to them wanting to do that. So, I know this all sounds pretty terrifying. In terms of prevention, there are some weaknesses we see consistently in organisations which can give rise to at least some of these problems. So the sorts of things that we see are poor recruitment, and that can be external new person coming in, and often it can be an internal person moved into a new job, but the wrong person in the job will cause problems and conflict that has to be sorted out sooner, as soon as you like. And so poor recruitment decisions, poor resourcing decisions are often the cause of this. Not using the probation period to manage performance. Often these conflicts and problems arise because something could have been sorted out in probation. It was known then, but it wasn't dealt with. Not having records of supervisions and not following up on actions from supervisions is another common problem that leads to these contentious cases. Not managing underperformance at the earliest opportunity, and managers just being too inexperienced or not knowing how to do it, and knowing how to do it in such a way that it's got an audit trail behind it. Sometimes line managers make mistakes and are visibly in the wrong to their team, so they might follow policies or fail to follow policies or make insensitive remarks, and those things haven't been addressed by the organisation, by the managers above that person, and that can become contentious because it looks like the organisation supports the manager that's doing the wrong thing. Another source of problems is things like out-of-date job descriptions and out-of-date contracts of employment. I think there'll be quite a few of these kicking around at the moment in organisations because there's been so much turmoil and transition during lockdown and pandemics. I expect there are, quite understandably, a lot of people that are working different days, different hours, different tasks, responsibilities, even different jobs, different locations to the ones that are in their contracted terms of employment. But when a dispute arises, it's rarely over that, but when you need to rely on the job description and the contract of employment, when you need to go back to first principles, what are we meant to be doing, these different parties in this employment contract, you need to rely on that paperwork. And if you haven't got it in place, you look you look poor if the matter is scrutinised externally, and you leave room, plenty of room, for the employee and their representative, whether that's a trade union rep or their legal advisor, to cast doubt on your credibility. So it's one of the most tedious but most easy things to do to help maintain, to help have a good bedrock for your employment practice. And also managers not addressing sickness absence consistently. Sickness absence is something that should be managed all the time, not just managed when somebody is in a dispute situation and they go sick. And typically that's what we see happening. So no absence gets managed in an organisation until there's one employee in a problem situation, and then they go sick, and then suddenly the policy comes out and people want to manage the sickness absence, and the individual says, that's another form of you victimising me or singling me out or discriminating against me because you've never managed anybody else's absence. So here's our top 3 recommendations, because you can't make changes to all of that immediately. But the top 3 recommendations are to train your line managers. Make sure that you've got a management induction for people that are becoming managers in terms of what's expected of them, particularly around equality, particularly around decisions they make involving their staff members. Train them to recognise problems, to recognise what they might do that would cause problems, and to nip those problems in the bud if they do start to arise in an empathetic and interpersonally sensitive way. I know that's a big ask. It's very different to training someone to follow a policy. We're talking about soft skills here, not hard skills, aren't we? Or a combination of the two, certainly, but we're certainly talking about soft skills. But it's important that those skills are trained in. Second thing I would say is have policies in place, have simple, clear policies and rules in place relevant to your organisation and its scale. Get them checked out by a professional before you adopt them, and keep them updated. One of the problems that can arise in these situations is there's a conflict of some sort or a problem, and a policy gets brought out, and actually the policy doesn't comply with current employment law or the ACAS code of practice. So the employer starts following the policy, and the policy itself gives rise to problems. So if you're going to have a policy, I'd say don't have one at all if you can't keep it updated. Sometimes if you're very small, Roots HR doesn't have policies for grievances or for disciplinaries. We just say that in our contracts of employment, in the event that actually one of these situations arises, we will use the ACAS code of practice to guide us in following a fair and lawful process at that time. So don't have policies if you can't keep them up to date. If you do keep them up to date, make sure they are compliant with the relevant legislation in place at this point in time. Train your line managers to know where they are and how to follow them, and how to use those policies, and then also have sound employment housekeeping in place. And by that I'm going back to this business of making sure your contracts, your changes to your contracts and your job descriptions are updated. If I was going to give you a 4th piece of advice, I said if you only do 3 things, but number 4 in hot pursuit for me is get your recruitment decisions sorted out. Get a good, sound, organisational, shared set of rules around how you can recruit and resource in an organisation, particularly for internal candidates. And the 5th one would be to train your managers to use probation periods and to use them really well. I would love a pound for every time you've sorted out a situation that could have been resolved in month 1 or 2 of a probation period. But it gives me no joy at all that that's the situation the client finds themselves in. So let's have a look at what happens if a problem does arise. Well, obviously I would say this, wouldn't I? But I would say if a problem arises, take advice as quickly as possible, and take advice throughout. Make sure that you're comfortable that you've got a competent person advising you. That might be internal, it might be external, it might be somebody on your board that can introduce you to somebody that can give you some free advice, but make sure that person has got qualifications, experience, and that they're really competent, and that you're comfortable implementing that advice. Ultimately, wherever the source of your advice is, whether it's Roots HR or anybody else, the organisation has to validate whether or not it decides to implement that advice. If we ever give you advice and you think, I'm not comfortable with this, I need to understand it better, why are they saying this? Come and talk to one of us. We won't mind in the slightest. Drill into it with us, explore why we've recommended that if you're not happy with it. And maybe we'll look at it differently with you, but we'll be able to explain why we've advised what we have. Follow your policies closely, but make sure that they are actually, as we said before, lawful and updated. If the policy that you bring out to deal with a problem is an old one or it's possibly out of date, start by saying to the employee, we're going to follow a grievance policy, but I just want to check out a couple of points on it that actually just make sure it's current and that it's viable. So I'll send you a copy of our current policy in the very near future. I just want to make sure it's okay first. Now, appoint appropriate officers to be the people that deal with whatever the problem might be. So typically this needs to be somebody above the dispute or the problem that's currently arisen. So typical scenario, employee, line manager trying to manage the performance of the employee. Employee says, you're discriminating against me, or you're harassing me, or this is bullying, or something like that. Appoint an appropriate officer of the organisation to be responsible for sorting that problem out, whether it's informally or formally. And that's going to need to be somebody that can hold the manager to account if the manager has got it wrong. So it needs to be somebody who's one step up from the actual from the level of the problem, which is why sometimes, for example, if the situation is between a chief exec and a senior member of staff, it needs to go up to the board. But appoint appropriate officers to both be responsible for the informal process, if there is one. There isn't always, but if there is, to be responsible for the formal process, if there is going to be one, because you would probably have to have somebody, if a decision's been made informally and the matter is still not resolved, it's no good going back to the same person that made the informal decision. You need to find someone different, really, if you possibly can. I know that's difficult in the smallest of organisations. It's not always possible, but ideally you need someone different to deal with the formal process, and you may need someone different again to deal with any appeal if it's a process that has an appeal connected to it. So you need to appoint appropriate officers. Some of the biggest muddles that we see are where organisations don't clarify who's responsible for a process or for an investigation, and different parties start communicating with the employee, and it becomes muddlesome, problematic. The best of these that I've seen done is where one officer is nominated and where there is a very clear email address that the parties, or email addresses that the parties are communicating through, as well as obviously through meetings and telephone calls and so on, Zoom, whatever it might be. But that's important. Clarify the communication lines with the employee. How shall we communicate with you? And make sure that that's going to be confidential. If the employee has a shared email inbox at work, you don't want the communication going to the shared email, do you? Even if they think it's okay, it's not okay. So clarify how best to communicate with them, and try for that not to be texts and WhatsApps about the important things in the situation. Obviously, try to make it, I say obviously, but we see it happen all the time. Try and make sure that it's email, try and make sure that it's that the meetings are recorded and notes are transcribed, and make sure that the communication is kept open in some way, shape or form with the employee, not with their representative, unless they are completely perhaps indisposed in hospital or something like that. Keep communications cordial. This can be really tempting. It can be really tempting to be curt or firm or a bit strong in how you reply to employees when their language can be very aggravating sometimes, very, very provocative. But from your perspective, you'll be grateful if this is ever scrutinised. Please keep communications cordial and civil. You can get, as you know, you can get any point across, can't you, in a respectful and cordial tone. Now, respect the contract of employment, and by that I mean look at what hours the individual should normally be working contractually, and give and make sure that communications with them are within their normal working hours. If the individual is suspended or if they are off on sick leave, they're still entitled to things like annual leave. So don't expect that just because they are not at work at the moment, actually their annual leave is being used up. It's not. And I'm sure most of you would be aware of that, but we have dealt with those sorts of situations. So what's in the contract of employment still needs to be, that's the psychological contract as well as the actual contract of employment, still needs to prevail during this situation. You've still got a duty of care to the individual as their employer. So that includes thinking of things like the impact on their mental health of the timing of your communications, the wording of your communications, the person that communicates, those sorts of things. And again, working with a professional advisor would enable those sorts of things to be tested and advised on before action is carried out. Keep a good audit trail. Make sure that you keep good records somewhere where organisationally they can be accessed if you leave or the person in charge of the thing leaves. That's a really big problem, particularly where it might take 2 or 3 years for a matter to come to the employment tribunal if it does, and the individuals involved may well have left by then. So make sure that you're getting a good audit trail, accessible and kept somewhere safe and confidential in the organisation. And don't prejudge. I know that might sound easy to say, but actually don't prejudge that this is the employee's fault or that it's the employer's fault or the line manager's fault or anything. All of these processes will need a careful, one step at a time investigation, listening to people, understanding what's gone on, and it's sometimes surprising what comes out in the course of them. There's lots more I could say about this, lots more. You can tell it's an area of passion and expertise and familiarity for me, can't you? But I think that's enough for now, because I'm going to move on to your questions. Before I do that, I just want to say to you that, again, if there are specific or unique questions that you want to ask us, if you put your questions in chat, everybody on the call can see them. So there's no confidentiality in this Teams environment. If you don't want to raise them here, that's completely understandable, and contact us separately. The contact details are on this slide. We offer a free hour of consultancy time by phone or email to every social sector organisation. So to use that, just get in touch. We don't work bank holidays, but we're Monday to Friday, 8:30 to 5:30. Other than that, we've also got a range of straightforward HR toolkits free of charge for employers in our sector. And for some things, for example, getting your recruitment sorted out, for example, these are a really good starting point. Each one's got an introduction, each one's got guidance notes, template letters, other documents, and a training presentation so that explains how to use them, and they're free for people in our sector. We've got recruitment, selection, pre-employment checks, induction, probation, agile appraisal, pay and benefits, managing wellbeing, personnel files, managing leavers, and we're about to launch managing sickness absence. That'll be out later in June. And then the final one will be managing underperformance, which is coming out in July. Again, to request these toolkits, just come through the office info@ or 01562 84 0060. We will also have a number of further free webinars coming up. So if you're signed up for our emails, then you'll be notified of them, and we'll promote them on social media as well. And we can offer a range of paid for consultancy services directly related to the content of this webinar. So things like subscription services for line managers to call upon for advice when individual employment matters or conflicts arise. We can undertake workplace mediation, we can undertake workplace investigations, we can handle formal grievances or disciplinaries or capability hearings on behalf of employers, and we can provide a range of training for managers, group training, webinars, video links, classroom style now that we're post-COVID, and other types of learning such as one-to-one business coaching, mentoring, one-to-one knowledge transfer. And we can offer bespoke support in case management in complex or contentious situations or where there's a higher amount of risk. Right, more than enough from me. I'm going to look at any questions that have come into chat. Let's see what we've got. Have we got any? Dan says, will a recording of this webinar be available afterwards? Oops, Dan, I've lost you. Just going back to the chat again. Oh, sorry, can't see the chat for the moment. Yes, Dan says, will there be a recording of the webinar available afterwards? And the answer is that yes, there will. And Tim says a guide or a template of a sample performance management policy would be useful. I'll tell you where that will be, Tim. Give me a month, and I'll make a note actually to ask Charlotte to send you our toolkit for performance management, managing underperformance, which will be out at some point in towards the end of July. A sample performance management policy, you might want to look at our agile appraisal toolkit, which I think will have that sort of information in it, and probably a template policy in there as well. So but we can get one of those sent out to you, no problem. There's no other questions at the moment in the chat. I'll give it a couple of moments before we close, but feel free if there's any other questions to pop them into chat now. Please do that. I'm waiting for people that I think are typing, because I can see some typing activity going on, I think. Go back and have a look in chat again. Looks like something new's coming. Oh, so Allegra's put one in Q&A. Gemma says, will your managing sickness policy cover mental health? Yes, absolutely. We've got managing sickness, absence, and we've also got managing well-being as a toolkit, Gemma. So I would suggest that you request those two from Roots HR. I'm going to have a look in Q&A. Okay, Allegra. So with contract updating, how important is it to update who the line manager is? Should we keep a copy of the old contract? Yes, I typically would keep a copy of an old contract, probably for at least for a couple of years after a new one has been, probably 6 years I would keep a copy of a contract for, and there's reasons around the Limitation Act as to why I would do that. With updating who the line manager is, yes, it is important. It is important to keep it updated, because actually the line manager can be a source of dispute as well. And if the line manager changes for a little while, perhaps because someone's going into hospital to have surgery and someone else is going to act up as line manager, you'd normally have just a light touch email that goes to the team to say, we're letting you know that so-and-so is going to be acting up for a while the other person's off. But if it's a permanent change, then yeah, I would say that ought to be discussed with the employee first of all to check they're happy with it. Often people are, but if not, there might be some problems to work through. And then a straightforward letter, just or email notifying them that the line manager is changing from X date. The person that you report to is often connected to your status, and it's often connected to how well how happy you are at work. So it is a part of the contract of employment that you're an important part of the contract of employment actually on a day-to-day basis. I hope that helps. Coming back to chat again. Oh, Gemma's thanking me. That's very, and Allegra, thank you. You're very welcome. Lovely to see some of you on here. There are people on this webinar that I've been working with for 13, 14 years. It's so nice. Claire, suggestions on how to manage low-level but disruptive behaviour, where there's a small group of colleagues who always have different opinions as to what their role is and what it should involve. Well, that's interesting, isn't it? I mean, I think what I would probably do is go back to first principles. What is the job description that the organisation needs to have done as a minimum by the people in these roles, and why? What's the justification for it? That would be my starting point in terms of being really clear in my own mind, and checking out whether the line manager is on side about that as well. Does the line manager agree? And if not, why not? I would not work that out with the employees until the line manager is aligned with the person that that needs to hold this particular line of work to account. So let's imagine that you are the line manager here, and you know this problem is bubbling. I think I would suggest you and the line manager, or HR and the line manager, make sure they're really clear about what the actual job description ought to be, or job descriptions might be plural, and why. And then I would have some either individual or group meetings. Often individual meetings get you to a place where you can deal with problems on a one-on-one. In a group meeting, one person's problem becomes everybody's problem, doesn't it? So I would try initially perhaps to have one-on-one meetings with people to understand where the differences come from, where the difference in understandings come from, and what's causing it. It might be that, Claire, you want to have a discussion with us separately to this about it, and to go into a bit more detail so we can understand the situation. But I hope that's helpful. Some of you are dropping off now, and thank you so much for joining me. It's been great. I'll deal with questions up to 12 o'clock, so we've got another few minutes worth. If anybody wants to put any more questions either in the Q&A or in the chat, but I understand that some of you, I say 12 o'clock, it's 1 o'clock, isn't it, that I'll be here till. So please do put any further questions in. Just going to have a quick look in Q&A. No, nothing new in there, but there's something popped into chat. People thanking. Lovely. Okay. So I'm thinking it looks like there aren't any more questions at this point in time. It looks like we've got to the end. People can pop your hand up if you're still typing. But I'm going to thank you all very much for joining me. It's been great, really good. This will be up on our website in a matter of a few days, if not sooner, as a recording, and I hope that it's useful to people in your team, and to you again if you want to listen back to it. Thank you very much indeed, everybody. Bye for now.